court counsel, what the state just told you, it's their story. What they think the evidence will be. You've heard it over and over. It's not evidence. And that's the nice thing about our system of criminal justice is what they say or what we say the evidence will be. It's not about that. It's about what the evidence actually is, as found by the 12 of you when you deliberate. Unless they present proof beyond a reasonable doubt from the witness stand or from documents submitted into evidence, everything they just said, your verdict must be not guilty unless they prove it. We spoke a lot in voir dire about the presumption of innocence and proof beyond a reasonable doubt, and how important it is to hold the state to their burden of proof. They're not just words on a page, but important backbones of our criminal justice system. It's not like a civil case where you just have to tip the scales by ever so slight a margin. A presumption means that despite what Mr. O'Brien just told you about what they believe the evidence will show, you have to presume the opposite. You have to presume Mr. Golsby is innocent unless they prove proof beyond a reasonable doubt. No evidence has been presented yet, so the presumption has not been overcome. And when presented, it must be worthy of belief from you. As you listen to the evidence, listen to both the direct exam and the cross-exam. Ask yourselves with each witness, with each document, does it lend itself to reasonable doubt as to any element of any charge? Would I be willing to rely and act upon it in the most important of my affairs? Decisions like what course of treatment to have for a life-threatening illness, what school your child should go to, and as the judge said, decision on whether to put somebody that you love in a nursing home. Those are important decisions you make in your daily lives. That's the quality of evidence they must present to you. The presumption of innocence remains with Mr. Golsby throughout this trial. There will be evidence presented by the state in this trial that we may not contest. We may not ask every witness a bunch of questions. That still does not relieve the state of their burden of proof in this case. We do not have to present any witnesses on our own, and we don't plan to present any at this point in time. We have no burden of proof whatsoever. We do not believe the state can overcome their presumption of innocence and prove guilt beyond a reasonable doubt. Pay careful attention to the evidence submitted or lack thereof as to whether the homicide was committed with prior calculation and design or pre-planning, an element the state must prove to you, and which the court will define to you later. Pay careful attention to the evidence of when the death occurred in relation to when the alleged kidnapping, robbery, and rape occurred. How much time passed in between? The state discussed video evidence in terms of Mr. Golsby's statements. Does the video answer questions about the murder itself or raise more questions? Is the state relying on Mr. Golsby to prove their case? What elements of the charges are missing in the videotape, and can the state prove it with other evidence? You will see that Mr. Golsby did not tell the complete truth in his interrogation with the officers. Few suspects do. But he's not on trial for not telling a complete statement. He did agree to talk to the police for approximately 6 hours. See, when it comes to closing argument, whether the state asks you to believe Brian Golsby and what his statements prove or don't prove. Consider what he did accurately provide to law enforcement. The state also discusses GPS evidence. It gives you approximate locations, but it's nothing more than a set of location points. It does not tell you who was doing what at that time. It does not supply mental elements, the state of mind. See if there's any evidence of the mental elements presented during this trial by the state. The evidence will show that Reagan Totes was driving the vehicle throughout this whole ordeal, and that she was the one that got out at the Turkey Hill gas station and pumped gas. No evidence that any suspect was outside the vehicle at that time while she pumped the gas in full view of other people. The evidence will also show she was driving the vehicle when the car went through the bank drive-thrus. Consider the motives of some of the witnesses who may come in and testify, and whether they have bias. You will receive an instruction of law relating to the credibility of witnesses, which says one of the things you can use in your determining the credibility of whether the person has bias. The state indicated it will present DNA evidence. DNA does not tell you the how, the why, or the when. It only shows two things at one point in time had contact with one another. The evidence will not give you a time frame on when items were deposited in terms of the cigarette butts. And also consider with the DNA how the samples were taken, when, and what samples were used and what samples were not used. Consider what was found on the gun, what was not found, and what was not considered or not tested. As to the crime scene, look at what was collected, not collected, tested, or not tested. You will hear evidence that Mr. Golsby was on an ankle monitor, but you will not hear any evidence that the monitor was being checked in real time, or that any sounds or signals went off at all during the time period involved. Consider what measures the adult parole authority did or did not take as to Mr. Golsby's supervision. When all the evidence is in, we will stand back up and explain what charges and elements within those charges we think the state did not prove. We will ask you to acquit on those charges. Hold the state to their burden of proof. Ask yourselves when the evidence comes in, do I have a reasonable doubt as to that charge because of what the evidence shows or does not show? When the evidence is in, the state will not have proved to you sufficient evidence to prove the charges beyond a reasonable doubt. And therefore, when we stand back up in closing, we will ask you to acquit on those charges. Thank you very much.